Section 22. Will you get paid? Customer or client, or no representation? That is the question. The question every agent must ask early. By now, one thing should be very clear. Representation and compensation must be discussed early, clearly, and in writing. For many years, agents were trained to ask sellers, "Are you currently listed with another broker?" That was important because if a seller had already signed an exclusive listing agreement, asking them to sign another one could expose the seller to owing more than one commission. Today, that same idea applies to buyers. It is no longer enough to ask, "Are you working with another agent?" That question is too vague. A better question is, "Have you signed a current, valid, exclusive buyer-broker agreement or any other written representation agreement with another broker?" That one question can prevent a lot of problems. A buyer may have spoken with 5 agents, attended 3 open houses, and received automated MLS searches from someone else without being exclusively represented. But if the buyer has signed an exclusive buyer-broker agreement, that is very different. Before you enter into your own representation agreement, you must know whether an existing agreement already exists. Working hard does not guarantee payment. Here is a lesson every real estate professional needs to learn early. You can work hard and still not be entitled to a commission. That may not feel fair, but Arizona law is very clear. If you want to collect compensation from a buyer, you need a written employment agreement that complies with Arizona law. Imagine this situation. You work with a buyer for several weeks. You show them homes. You answer questions. You send listings. You discuss neighborhoods. You even show them one property that is not in the MLS. Then the buyer decides to have their sister, who is also a licensed broker, write the offer on that exact home. The transaction closes. Do you automatically get paid because you showed the property first? No. Without a written buyer-broker employment agreement, collecting a commission from the buyer would be extremely difficult. This is why the buyer-broker exclusive employment agreement is so important. It is not just paperwork. It is the agreement that explains the relationship, the services, the term, and the compensation. Details matter. Arizona courts have made it clear that real estate employment agreements must be handled carefully. In one Arizona case, a buyer signed a buyer-broker employment agreement, but the broker did not sign it. After the buyer purchased a property through another agent, the original broker sued for the commission. The court ruled that the agreement was not enforceable without the broker's signature. That may feel harsh, especially because the buyer had signed the agreement. But real estate brokers are expected to know the law. The lesson is simple. Details matter. A real estate employment agreement should be clear, complete, signed by all parties, contain the material terms, include compensation, and have a definite beginning and ending date. Do not assume. Do not leave blanks. Do not forget signatures. Do not rely on "we all understood." If it matters, put it in writing. The Statute of Frauds, Arizona's Statute of Frauds, requires certain agreements to be in writing, including agreements employing a broker to purchase or sell real property for compensation. In plain English, if you want to sue for a real estate commission, you generally need a written, signed agreement that establishes your right to compensation. A handshake may feel honorable. A verbal promise may sound sincere. But when money is disputed, the written agreement is what protects you. This is true for listing agreements. It is true for buyer-broker agreements. It is true for compensation agreements. The more important the issue, the more important it is to document it correctly. Real estate employment agreements, Arizona real estate employment agreements, must be written in clear and unambiguous language. They must include all material terms, including compensation. They must have a definite duration, with a beginning date and expiration date. They must be signed by all parties. These requirements exist to protect consumers from unfounded commission claims and to make sure everyone understands the relationship before services are provided. That is why brokers are so careful about listing agreements and buyer-broker agreements. They are not just internal office paperwork. They are enforceable contracts when completed properly. Listings and commission. A listing agreement establishes the duties between the seller and broker and explains when the broker earns compensation. In many cases, a listing broker earns a commission when they produce a ready, willing, and able buyer on terms acceptable to the seller, or when the property sells according to the listing agreement. Some listing agreements also address what happens after the listing expires, especially when the eventual buyer was introduced to the property during the listing period. This is why expiration language matters. If the agreement does not clearly explain when compensation is owed after expiration, the broker may have difficulty collecting later. Once again, details matter. Buyer-broker agreements. The buyer-broker exclusive employment agreement performs a similar role for buyers. It explains that the buyer is hiring the broker to assist in locating property, negotiating terms, and helping with the transaction. It also explains how the buyer's broker will be compensated. In today's market, this is critical. The seller may agree to pay the buyer's broker. The seller may agree to pay part of the buyer's broker compensation. The seller may refuse to pay any of it. If the buyer has signed a proper BBEEA, the buyer understands what happens in each of those situations. There should be no surprise at closing. Do not interfere with existing agreements. Another important rule is that brokers must be careful not to interfere with existing exclusive employment agreements. If a seller is already listed, do not attempt to obtain another listing unless the proper legal and ethical requirements are satisfied. If a buyer is already subject to an exclusive buyer-broker agreement, do not attempt to create a competing representation agreement. This is not just professional courtesy, it is risk management. It protects the consumer from owing multiple commissions. It protects you from ethical complaints. It protects the reputation of the profession. A practical buyer conversation. A strong buyer consultation might sound like this. Before we begin, I need to ask whether you have signed any written buyer-broker agreement with another real estate broker. I am not asking whether you have talked to another agent or attended open houses. I am asking whether you signed an exclusive agreement that may still be in effect. That explanation helps the buyer understand why the question matters. If the buyer says yes, direct them back to their current broker. If the buyer says no, you can continue with your agency discussion, explain your value, review the READE, discuss compensation, and complete the BBEEA before showing homes. That is how professionals protect themselves and their clients. Will you get paid? The answer depends on whether you handled the relationship correctly. Did you ask if the buyer or seller already had an exclusive agreement? Did you explain agency? Did you discuss compensation? Did you complete the proper employment agreement? Was it clear? Was it signed by all parties? Did it have a beginning and ending date? Did it include the compensation terms? If the answer to those questions is yes, you are in a much stronger position. If the answer is no, you may have worked hard without protecting your right to be paid. Broker tip: before showing property or investing significant time with a buyer, confirm whether they have signed an exclusive agreement with another broker, explain your value, and complete the BBEEA if they want representation. The best time to protect your commission is before the work begins. Online discussion question: why is asking "Are you working with another agent?" not enough? Because a buyer may be casually communicating with another agent without being bound by an exclusive agreement. The better question is whether the buyer has signed a current, valid, exclusive buyer-broker agreement or other written representation agreement. Question: why are written employment agreements so important in Arizona real estate? Answer: written employment agreements establish the relationship, explain compensation, include the material terms, and help protect both consumers and brokers if a commission dispute arises. Question: what lesson should agents learn from cases where a buyer-broker agreement was not signed by all parties? Answer: details matter. A real estate employment agreement should be complete, clear, dated, signed by all required parties, and include compensation and duration terms.